Hi, welcome back. It's Naomi Menon here, the Head of Compliance and Operations from AFTA. And hopefully you joined us for the first series on advertising. Today we're going to be talking about some other parts of Australian consumer law, which is the consumer guarantees, and I'll also touch on unfair contract terms and unconscionable conduct. So we're going to look at the consumer guarantees, and there's two documents that we'll send out to you with the email following the webinar to the consumer guide, but there's also a guide for businesses and practitioners, which are good to have on hand if you want to look into the information a bit more. So today's all about consumer protection. There's two parts to the consumer guarantee. So a large part of the consumer guarantees is based on goods, and we're not going to really focus on that today. What I am going to focus on is the consumer guarantees in relation to services. So the consumer guarantees relating to goods, I have listed them here just for your general knowledge, and it's good for you to also be aware as a consumer yourself, and they relate to obviously the right to sell goods, that the possession is not disturbed, which means that they have the right to actually sell it. There's no undisclosed securities, say for a mortgage on a car or something like that. Goods are of acceptable quality. They're reasonably fit for purpose, which is similar to the services guarantee, which we will talk about quite in depth. And then there's that the goods correspond to any description about them. The goods correspond to any sample or demonstration model. That repair facilities and spare parts are reasonably available, and that any additional warranties will be complied with. So really more affects the retail sort of sector and also the manufacturing sector. So the consumer guarantees for services apply if you're supplying a service to a person or business that costs $40,000 or less, or more than $40,000, but it's for a normal personal or household consumption. So travel would fall into that. So even if it was a cruise, so some of the cruises we see are $50,000, $60,000, that would be covered by this because it is for normal personal consumption. So where that applies, the three consumer guarantees for services are due care and skill, fitness for purpose and desired result, and that there be a provision of the services within a reasonable time, which does relate a little bit more to services such as, maybe you've agreed to mow the lawn or something, that it be done within a reasonable time. So the two we're going to focus on today are due care and skill and fitness for purpose. So the first one is section 60 of the ACL, due care and skill. And what it says is if a person supplies in trade or commerce services to a consumer, there is a guarantee that the services will be rendered with due care and skill. What does that mean? There's no actual definition of due care and skill. The ACCC lists the two requirements are the provider of the service must have an acceptable level of skill in the area of the activity, and that the provider must exercise due care in supplying the service. So it's sort of a bit vague. It doesn't really explain it. So what we have to do is we have to look at case law and decisions made by courts and by tribunals, and I'll also share today with you some of the decisions we've made here at AFTA that sort of help you understand where the duty lies and what your liability is. And I will state up front that each case and complaint does most definitely turn on the facts of that exact complaint. So it can be very difficult, but hopefully I can give you some understanding. So I picked this case, and this was a case that went to NCAT, the New South Wales Civil and Administrative Tribunal. And I've chosen it because it's got a lot of different components, and actually components that we actually see quite regularly here in complaints. So the complainants made a complaint about a number of issues on a tour organised by this Great Wall Travel Service, who were not ATAS accredited, which so is why I've decided to use them. And they claimed that they lacked due care and skill. And there's also claims of the Section 61 fit for purpose, which we'll talk about in a bit, but there was a number of factors. One of them was a cancellation of a scheduled bus trip in Quebec. The other thing was, as in New York, none of the scheduled visits that they had to all of the sightseeing places occurred. And then there was also a component that on their West Coast tour, it failed to deliver what it had said it would, and that they had failed to be picked up from the airport. So in this case, they go through each of the different complaints, and I'll go through each of them and what the decision was, so you can it's a good indication basically of where they found a breach of duty of care and not. So the first one cancelled the trip to Quebec. The trip was cancelled due to snow and weather conditions, and the judge had said that that was a prudent decision. So he said there was no claim under Section 60 or 61 in this case. They also tried to claim Section 18, that it was misleading and deceptive, which we covered in the Part 1, but he rejected that claim as well and said that no one could have known that there was weather and snow on the day, so no claim here under either of those. So there was a claim about the Empire State Building that they had paid $43 for this ticket, but they didn't go. And $40 of that had been refunded, and they went on an alternate trip to the Jersey Shore. They paid, they said that the $3 difference was a tip for the bus driver, and the judge pointed out that the applicants didn't object at the time and that they actually received that benefit, so they had no claim under that as well. However, with the visit to the scheduled sites, the first one, the Museum of Modern Art, was actually closed Mondays, and that was the only day that they could have visited. So it was held, this was the responsibility of the respondent, the agent, to know and schedule the tour for a day it was open. And so this claim succeeded under Section 60. It was a breach of their duty of care in arranging that. The United Nations, again, access wasn't possible due to the timing that they were there, and it was held that the responsibility of the respondent to know and schedule the tour appropriately, and again, that claim succeeded under Section 60. In the Fifth Avenue, there was a 2-hour window. All of the tourists were non-speaking English, and it wasn't what was promoted. In the guide, it had said that in their itinerary that it would be a guided tour, and it wasn't. So it was held that the respondent had the responsibility to exercise due care and skill in organising a tour to Fifth Avenue, which took account of the applicant's circumstances. So that succeeded, as well as a breach of the duty of care and skill. And also the same for the scheduled visits to the Rockefeller Centre, Times Square and Broadway. And also for the West Coast tour, it was held that that was a duty. They were left on their own to find their way to the hotel, and various parts of that tour that had been in their itinerary was not, did not occur. So I'm in the terms and conditions of the agent, they had limiting liability. So what's really important to know about the consumer guarantees is that you cannot contract out of the guarantees. So if you have in your terms and conditions, for example, it says, you know, exclude all liability, then that would just be considered void, because you cannot excuse yourself from the liability of the consumer guarantees, hence the word guarantees in the name. So where you limit, that's permissible, but where you exclude, that is void. So you're probably wondering, okay, well, how much did they have to pay? I'm going to talk about that a little bit later when I talk about major and minor failures. So I'll come back to that, and I will tell you the answer for that in a little bit. Another example on due care and skill that we had here at ATAS was an agent booked a resort, and actually what happened was the resort in Fiji had one of those film crews going there for 6 months, so they cancelled it, the resort cancelled it, and so the agent rebooked. The complainant wanted a number of different criteria. One of the criteria was he wanted a pristine beach. Now, he complained that the beaches weren't pristine and that the agent lacked due care and skill, because this is what he had requested. And even though a lot of the other components were all met, especially to do with size of the party visiting and etc., but we found that there was no breach. The agent had not breached their obligation. This was also appealed. Decisions made by myself can be appealed to an independent committee that is made up of of 2 consumer representatives and 2 travel industry representatives, and is headed by the chairman, who's an ex-High Court barrister, and the committee also upheld that decision. And in most instances, they do uphold, but they can also alter the outcome that I issue. I would have been happy to go to Fiji and check out the pristine beach if it really came down to it, but unnecessary. So that's due care and skill. I'm going to talk now about fit for purpose. And what you'll find is when I go through the examples after fit for purpose is, in most cases, the due care and skill and the fit for purpose do cross over, and a lot of cases where one allegation of a breach has occurred, it's likely that it'll also be 61 as well. So like that case we just looked at, the Great Wall Travel, it was a case of 60 and 61 being found in breach in a lot of the cases. So fit for purpose basically is where the consumer expressly or by implication makes known to the supplier that there's a guarantee that any product resulting will be reasonably fit for that purpose. So we do hear a lot, oh, it wasn't fit for purpose, it wasn't fit for purpose. And the first thing that we say is well, did you make it known to the supplier? So it's a key element of this clause that sort of gets overlooked or is misunderstood. So it does have to be something made known. And part 2 of 61 goes on saying that where the consumer makes known a person by prior negotiations, that the guarantee, you'll see down the bottom highlighted, the product resulting from the service will be of such a nature and quality, state or condition that they might reasonably be expected to achieve that result. So the key takeaway is it has to be made known. So I'll give you a couple of examples. We do see fit for purpose a lot. This was a recent complaint that we had, and the consumer had specifically requested that they wanted full service on the aeroplane holiday and that they needed wine. And they'd specifically stated that, who doesn't need wine? But they booked the airline on the recommendation of the agent, and then the consumer actually found out for themselves before leaving that it wasn't full service and they could only have beer. Now, the agent had actually made a number of suggestions like, oh, well, you can take little bottles of wine on board, which I actually checked, and those small little bottles are over the custom limit of what you're allowed to take on board of liquids, so that wasn't a plausible solution. Then they also suggested, oh, we'll take some duty-free on board and you can drink. A quick check of their website clearly showed that that was not permitted to drink duty-free on board. So both of the solutions that they'd come up with, I went back to the agent and said, well, they're not plausible. So they came up with an amount that they would offer to mutually resolve. The complainant came back and said, oh, no, I want this much more. It was an extra couple of $100. And we found that what the agent had recommended was fair and reasonable, and we liaised with the complainant and said this is a fair and reasonable offer, and they both did accept it. And so we were able to mutually resolve that before they went on the holiday, and now the agent knows that that is not a full-service airline indeed, when they had stated it was. So what may seem not important to one person can be very important to another, especially, as I said, if it's made known that it's a specific requirement. Okay. Another ATAS example is a couple of young guys were travelling around America. The agent was well aware they were under 21. In Las Vegas, booked them a hotel, but the consumer found out that actually under 21s weren't allowed in that hotel. So the agent had offered some alternatives, but we did some research and none of them were in a similar location. They were way up the strip, far from where he had planned a number of activities and made other bookings. And there was one hotel that was of a similar alternative that he had found, but that the agent couldn't sell. It wasn't on their books. And we negotiated a resolution that they paid a sum that would cover that hotel for him, so that he was happy with what he got, and the agent was happy with the resolution as well. Another quick example from us is we had a person turn up to their river cruise in somewhere in Europe and went on board and found that their cabin was actually below the waterline and didn't have a balcony. So again, the first thing we ask is, well, did you specify that requirement? And we went through all of his emails, all his communication, and he had asked for a balcony for his hotel, but he hadn't made any specifications for the cruise. And the information regarding his cruise was on his invoice, which he had for a long time and never questioned. So, you know, we found no breach and no refund in that regard. And the last example I'll give you is we had two teenage girls going on a Japanese holiday, and they arrived at one of their hotels and found out it was a love hotel. So they immediately checked out, and in this instance, we required the agent to refund those nights. Any quick 5-second Google check could show you that it was a love hotel, and the fact that the agent didn't have that information in their system, well, that was a flaw on their behalf, because it definitely wasn't fit for purpose for two teenage sisters. Okay, so where you do fail to meet a guarantee, a consumer obviously has the right against the supplier to have to provide a remedy. So to put right a fault or a failure to meet that obligation. So where there are failures under the guarantees, they can be classified as a major or a minor failure. And this is important to working out responsibilities. So a major failure, the consumer is the one that can cancel the services and get a refund for the parts of the service not already consumed, or they can keep the contract and get compensation for the difference in value. And in most cases with the travel, it does end up being that people still going on the trip or the travel that they've booked, so they're keeping the contract and then they get compensated for the difference in value. So a major failure is one where a reasonable consumer would not have acquired the services had the consumer been fully aware of the nature and extent of the failure. If the services create an unsafe condition or they're substantially unfit for purpose. Now, what becomes difficult with the major versus minor is every single person that's ever going to complain to you is always going to say, well, I never would have booked that if I had known that. But if they have kept that contract and gone on it, then that's where you've got to work out what that difference in value is, and we'll talk about that in a bit. But straight away, I can tell you, everybody, we get regurgitate the consumer law back to us saying, oh, it's a major failure, I should get a full refund. That's what it says on the consumer law website. I want a full refund, but it's definitely not that. So the other part of the equation is it a minor? So this consumer must give the supplier who provided the services an opportunity to fix the problem free of charge and within a reasonable time. And that usually would happen for a minor incident, right? You'd fix the problem up, there'd be no problems within a reasonable time, hopefully before they've left for their travel, and everybody's happy. If a minor problem with the service can be fixed, the consumer can't cancel and demand a refund immediately. So that's something that you can always consider if somebody is over the top, and there are those people. Oh, I want a full refund, whatever. Well, you could state, you know, this is actually a minor fault, so we can correct this, and you're not actually entitled to a refund. So keep that major versus minor in your mind in the event that there is something does go wrong. If the supplier does refuse, however, to fix the problem or is taking too long, then a consumer can get someone else to fix the problem and recover costs, or then cancel and get some or all of their money back. So as long as you're doing it within a reasonable time frame and fixing the problem, shouldn't be an issue. But if you don't, then then that right goes back to the consumer for them to choose. So I guess that sort of sums it up. So if it's a minor fault, the supplier can choose the remedy and how you want to do it. But if it's a major fault, the consumer chooses the remedy. There is an exception for the fit for purpose. So a consumer is not entitled to a remedy if it's because a supplier has failed due to something someone else said or did, or if it's beyond human control that happened after the services were supplied. So can a consumer get a refund for changing their mind? A supplier does not have to give a refund when a consumer simply changes their mind about a services. But if you do have a policy about how you do act with your refunds, and you should obviously, then you must abide by that. So a consumer can also claim compensation for consequential loss from a supplier if you fail to meet. So that's really consequential, is like out-of-pocket expenses. So if there was additional costs that came out of their pocket, then that would be covered. And we definitely do deal with that and see that as economic loss. So compensation should put the consumer in the position that they would have been in if the goods and services had been met. And consumers think that it's probably this much money when it's usually about this much money. The amount of people that think, oh, I should be getting another trip, all expenses paid back. I think their expectations are wildly out of whack with the actual reality of what you're entitled to. But that's where we can really come in handy in helping you, because we put it in black and white and break it down and quantify it. So let's go back to that case that we went through before that looked at a whole bunch of different problems. So there's a few statements that I'm going to go through in it, because it does sort of help that even though that they found that there was all those breaches, sort of help you understand at the end how they came to working out a compensatory figure. It's a matter of common sense that the applicants would not have paid for a tour organised by the respondent. So what he's saying is it's a major failure, what we discussed before, or that they would not visit these sites if of the tour being left to their own devices. So under the ACL, section 236 says the best solution, best adapted to give the applicants damages which will most fairly compensate them. So what it was important about what he said in here was that if they were to send them all back to New York, that would overcompensate them. And if the complainant had to pay themselves to go back to New York to see it, then that would undercompensate them. So the principle is clear, it states, if the court finds damage has occurred, it must do its best to quantify the loss, even if a degree of speculation and guesswork is involved. And it usually is. We have to do it here, and we try to work it out, break it down by days, hours, attach a dollar figure to that, but come up with something tangible. You know, a lot of people, when they're trying to get a number, they'll just have some crazy number plucked out of the air. I think I deserve $5,000. Well, why do you think that, and how do you quantify that? So also added here, the principle applies only when the court finds that loss or damage has occurred. So it is not enough for a plaintiff merely to show wrongful conduct by the defendant. So that's sort of important, because if you haven't entered a contract as well and you've done something wrong, then they're not going to be entitled to any damages. You have to have suffered some sort of economic loss. We only deal here in economic loss. If a complainant wanted to claim pain and suffering and stress, then we would recommend that go to a court, because that's not considered economic loss. That's non-economic loss and very hard to quantify. Not a lot of cases are on it in travel, and again, a very, very hard thing to quantify. The way we say it here and sum it up, it's the difference between what you received and what you paid for is what you need to try to quantify. So does anyone want to take a guess what you think? The court ordered that each person should be repaid, be refunded for not visiting all those sites in New York. Anyone like to hazard a guess? No? Well, okay. Well, the judge held that $100 per person for not visiting the sites and plus $60 per person for the West Coast tour. So, you know, the claimants were wanting, you know, to basically go back to New York and get a whole free holiday. And as you can see, the reality versus the expectations is wildly off. And as mentioned before, we do get this a lot, where people are asking for an unrealistic amount. But even here, this case, it was, you know, they ended up with $160, you know, per person for missing out on those things. So I guess don't initially be very afraid as well, you know, when you think maybe you've breached it. That's probably the harshest part of it, is having a breach. Here we try to obviously make sure that the focus moving forward is that the breaches don't happen again. And, you know, sometimes it's just, you know, there's human error and things happen. But if it's some sort of a systemic issue in the way you're running the business, then we'd look at addressing that. Okay, a couple more cases before moving on. Obviously, I have put the Scenic case here because it's very familiar and been reported a lot in the travel trade press, but that was also a breach of the due care and skill section 60. And if you don't know about that, that's where, due to the floods, the boats, they put them on buses, and there was elements of it not being fit for purpose as well. But that's probably a very recent, very well-known case that they did require to refund the entire amount, as opposed to the difference between. I think that was a major failure is what was held in that. And another example, VCAT, a recent one that I've seen, an itinerary had stated a scheduled return date of the 30th of September, but the e-ticket actually was the 16th of September. And the agent had stated that was because of a limitation on the ability to book in advance, and had intended to rebook once it became possible to do so. But the traveller found out on the September the 8th when they were travelling, and there had been some conversing between the agent and the consumer via internet messaging service, but they hadn't, it wasn't sort of locked down. It was discussed a bit in the case. They had said, oh, there's no flights on that date, but they didn't really offer any alternative. Some people did take the earlier flight, but there was a number of people that didn't because they'd booked other, you know, shows and tours, whatnot. And the agent had said in this case, oh, well, you weren't permitted to make alternative ratings because you should have checked with us first. But in this case, because the judge actually found that it was a major fault, that they hadn't booked the right date back, because it was a major failure, the consumer was allowed to make that decision themselves and to choose. And he found that it was a breach of both 60 and 61, and had to refund the cost of the additional flights that they had booked to return. Okay, so that is a wrap up of due care and skill and fitness for purpose. As I said, they sort of do cross over a lot, and we'll send you out those documents, but by all means, you know, contact us if you ever have any questions about that. So I'll move on now and cover unfair contract terms and unconscionability, which won't be as long. We should probably wrap it up in 10 minutes. So unfair contract terms, there's another 2 documents, and we'll also attach this to the webinar issued by the ACCC, which is a guide for businesses. And there's also a fact sheet for some changes. So unfair contract terms only used to apply to consumers, but they also apply to small businesses now, which means if you're a small business, you can also claim that's an unfair contract term with another supplier. So what's important is it must be a standard form contract. So it must be one of those contracts that just basically comes part and parcel, not really looked at, edited, negotiated, standard form. So usually, like, you know, what comes up a lot is mobile phone. The ACCC definitely focused on that. And so the role of the court is to determine whether a term in a standard form contract is unfair. And once a term is declared by a court to be unfair, that term is void. A term of a consumer contract is unfair if it would cause a significant imbalance in the parties. And I think that's the sort of key word it comes up when you talk about this. It's about significant imbalance. There has to be some sort of unilateral imbalance in the power. It's not really necessary to protect the legitimate interest, so it's in there but not necessarily should be in there, and it would cause detriment to the party if it were applied or relied on. In deciding whether a contract in a standard form consumer contract, court may consider a range of relevant matters, but they must take into account a whole list of things here. I'll just go through them quickly and point out the key words. They look at the bargaining power. They look at whether there's been any discussion before entering into the contract, whether the other party was in effect required to accept or reject, so you can't know in between negotiations. Opportunity to negotiate the terms given an effective opportunity, whether the terms of the contract take into account the specific characteristics of the transaction that you're dealing with. So one of the recent examples in VCAT was a mobile phone. Basically, it stated a customer may have breached the agreement in a manner which is inconsequential, yet faces the prospect of having the service terminated. Further, if the customer changes his or her address, which will not necessarily be the address for billing, this will also provide a ground to AAPT to terminate. Because these provisions are so broadly drawn and are one-sided, which is the real key, one-sided, they are unfair terms. So as I said, the rest of the contract is still fine. It is just the clause that is unfair is considered void by the court. So the ACCC at a federal Commonwealth level has a responsibility of enforcing unfair contract terms, and the states and territories also enforce these in their jurisdictions, and they work together to ensure a consistent approach. We do get a lot of people here stating, oh, well, that's an unfair contract term. We don't take those on because the legislation specifically states that only a court or tribunal can make a decision that a term is unfair. So that's the way that it stands now. And so we, as I said, don't take those on. Okay, so very briefly went over unfair contract terms, but I have put out a lot of newsletter information about that, and if you are after more info, you can contact us. As I said, I will attach those two documents. Lastly, just want to touch on another section of the ACL, which is unconscionable conduct, just so that you understand what that is. And it's generally meant to be conduct that is so harsh that it goes against good conscience. So all businesses under the consumer law must not engage in unconscionable conduct when dealing with their other businesses or their customers. So how to avoid engaging in unconscionable conduct? Do not exploit another party. All of these are be pretty straightforward. Do not reward your staff for unfair pressure-based selling. I don't say that we would see a lot of what I would think would be unconscionable conduct, which is great. All of our agents do all of the things that are required of them, so it is rare, but I will show you or tell you where I do see some where this question could be raised. Take care to be reasonable when exercising your rights under a contract. Consider the characteristics and vulnerabilities of your customers. So they say, for example, you know, use plain English when dealing with customers. What I would also say is be careful when dealing with elderly people. In case law, usually most of the unconscionable conduct cases involve elderly. So I think extra care needs to be taken when taking money from elderly, especially a lot, and especially where it's non-refundable, and making sure that you've been very clear on the contract terms, the itinerary, if a portion is non-refundable, and where travel insurance plays in that, because some elderly people might not be able to get travel insurance, or it's going to, be a barrier, the cost-wise, for them to doing it. So make sure that would be the area that I would say make sure you be very careful when dealing with, which people call, this is what they say when they feel that their elderly grandmother's been taken advantage of. They say unconscionable conduct. So make sure the contracts are thorough, easy to understand, not too lengthy, don't include harsh or unfair or oppressive terms, and ensure that you have clearly disclosed important terms. And as I said, non-refundability, a big one. Ensure customers understand the terms of any agreement associated with the transaction and give them the opportunity to consider the offer. Observe any cooling off periods and give customers the opportunity to seek advice. As I said, that sort of, again, with the elderly, just if you're going to take deposit and it's non-refundable and you haven't been clear or given them the correct documentation prior, and given them the opportunity to seek advice, that's where I'd be careful regarding unconscionability. Happy to say, though, I have not had any cases that I would consider unconscionable. If things go wrong, be open to resolving complaints. I'll be doing a complaints handling webinar later in the year, but it's really important just to listen and acknowledge and respond formally and professionally, and most things can be resolved that way, which I'm sure you're all well aware of. But yet we do see cases where people take a defensive position as a default, and it just escalates from there, basically. So that is today's webinar, Duty of Care and Skill and Fit for Purpose. If you have any questions, I'm happy to take them now, or happy for you to fill out the survey and pop in a question. I'll get back to you over the next week or two. But thank you for your time again, and hopefully later on in the second half of the year, we are about to undergo some changes to our ATAS charter and our ATAS code of conduct. We've just been through a review. So we will have some changes on that, and I'll definitely be doing a webinar to cover that. Somebody's asked about where we can access part 1. It is on the website. There is a page on the AFTA website that contains a link. So if you just go into AFTA and search webinars, it should come up with all of them, and you can find that link there. If you can't, just email me. I haven't put my email up today. It's Naomi, Naomi, at afta.com.au. Are agents entitled to fees for work done? If you wish to apply fees, then that's fine. You just need to make that clear up front and add it to your terms and conditions with the schedule, and I definitely see that, and people do that. It's obviously a business decision that you need to make, which is personal to your business, but I would recommend adding it to some sort of schedule in your terms and conditions, and just making it clear up front. And of course, you can have cancellation fees, you can have any fee that you want. You just need to disclose it and make it clear, and as I said, pop it in your T's and C's. Yep, somebody similar question. Yeah, and look, I do see that people do that where they cancel and don't. So just, work out as a business what sort of fee you wish to provide a wish to charge, and add that in. As I said, it's really about disclosure. People, I find, just get mostly upset because they haven't been told something up front, or feel they haven't been, and they get, it's always a rude shock when they cancel, and most complaints occur because of a cancellation, and people, you know, are shocked to find out just how much it costs. But if you're clear and upfront, it's usually not a problem. Okay, so look, I'm going to wrap it up there. If anyone has any other questions, by all means, as I said, put it in the survey or get in contact with me directly here at AFTA. Happy to help any of our agents at any time. And I look forward to another set of few webinars later on in the year dealing with the Charter Code and complaints handling. All right, well, have a great day, and until next time, we'll see you then. Bye.